If you're a surety and the accused is misbehaving, should you pull the bail? I often get calls from sureties acting for a client who's flirting with disaster. These sureties want to know whether they can or should pull the bail. Understandably, they don't want their child, friend, or loved one to go to jail. But they also realize that they've made a promise to the courts. And there's a third level of the analysis that I want to add to the discussion. If you're a surety and someone you've promised to supervise is misbehaving, consider these three things. First, yes, indeed, you have made a legal promise to the court to do your job. That means enforcing the rules of the order strictly. Second, if you fail to do your job and the accused person under your care gets caught and convicted, you could be sued for any money that you've pledged in what we call an estreatment hearing. And third, here's where things get interesting. Sureties should really consider whether lax enforcement really does their loved ones any favors in the long term. In my experience, people who misbehave while on bail have a tendency of attracting police attention. I've never quite figured out why this is, but whether it's because of poor judgment, sharp police instincts, or sheer bad luck, when clients of mine flout a bail order, a surprising number of them get caught. Getting caught means getting arrested, and getting arrested means acquiring new criminal charges. Why does this matter? Because if we compare the circumstances created by revocation on the one hand and detection and arrest for violating the order on the other, it turns out that quite apart from a surety's legal obligations, the reluctance to revoke a bail order really does an accused person no favors. When you revoke a person's bail, a warrant is issued for their arrest, but that warrant is not for any particular crime. It is simply because a key part of the release order, that is the surety, is no longer in place. Once the warrant is executed, the bail is canceled, the financial pledge made is terminated, and the person you were supervising is returned into custody. In other words, the case goes back to square one. If and when the accused wants to, they can reapply for bail. They can do so with a new surety. They can do so with the same surety. Because they've accrued no new charges, they may even stand in good stead to try to get bail without a surety. If the accused was released on consent the first time, provided the same conditions are met, the new bail will almost certainly be on consent too. If the first release was hotly contested, meaning that the Crown was opposed to their release, in many cases the new release won't be. I've seen many Crown attorneys recognize that a previous bail order should be respected, even if they have a right to oppose a new bail. Now compare all of that with the situation that's created where a surety is reluctant to pull the bail and the accused gets arrested. Well, now they have additional criminal charges to deal with. They could be as simple as violating a curfew. On the extreme end, it could involve engaging in new criminal activity. Regardless of the type of charge, any new charge means new jeopardy. And new jeopardy means a significantly reduced chance at making bail again. This can have a devastating impact on a case. Any judge asked to consider a new bail will be told about the alleged violation. The original surety, who might have proposed themselves again if they had simply revoked, is now compromised. The allegations could, and often do, paint them as a failure. If the accused has nobody else to turn to, proposing the same surety, although not unheard of, runs a real risk. If the Crown consented to release the first time around with the new charges, there's no guarantee that they'll do so again. In fact, they probably won't. If the Crown opposed the first bail, you can bet that they'll oppose even more vigorously this time around. All of this has an impact on the accused person's chances of winning the case. Because if the accused is unable to make bail due to their increased jeopardy, they're very likely to plead guilty. In cases involving first offenders, professionals, people with a tenuous immigration status, or any other client trying to avoid a criminal record, this means losing the chance to win and acquiring instead a lifelong criminal record. So should a surety revoke the bail? It may seem like exceptionally tough love, but in many cases it's just the right medicine. It's also the law. Thanks for tuning in.